Welcome to Diagnosing Health Care, a podcast featuring thought-provoking conversations about the latest legal, policy, and regulatory issues in healthcare. While these issues may seem like hurdles, we'll also look at the business opportunities and solutions that exist. Diagnosing Healthcare is brought to you by the healthcare lawyers at Epstein Becker Green, a leading law firm that has more than 40 years' experience serving clients in the healthcare industry nationwide.
Hello, everyone. This is Megan Robertson, back to host another episode of Diagnosing Healthcare. I'm an attorney in Epstein Becker Green's healthcare and life sciences practice in our Washington, D.C. office. This episode, we're discussing some new developments on a hot topic, one of my personal favorite topics, cannabis law. Our last cannabis episode in September 2020 gave a snapshot of the regulatory landscape of cannabis and cannabis-derived products. It highlighted the complexities of navigating the federal and state requirements around those types of products. Since then, there have been a few key developments that we want to bring to the attention of our listeners. First, starting with the federal level, FDA has issued some warning letters to companies selling cannabis or cannabis-derived products in the past, but these warning letters have tended to target businesses making claims that their products can cure or treat specific conditions, for example, cancer, Alzheimer's. However, on March 22nd of this year, FDA issued some new warning letters to two businesses, and these businesses were making claims that their topical CBD products offered general pain relief. These warning letters appear to reflect a shift in the enforcement mindset of FDA, broadening its net to target products making these sort of general pain relief claims due to the agency's concern over the use of CBD as an ingredient. More on this in a little bit, but first we're going to go to the stateside developments. We have a little bit of a different story here. On March 31st of this year, New York joined the growing number of states that have passed legalization bills, enacting a bill that, among other things, legalizes adult use cannabis. It also creates a state agency called the Office of Cannabis Management, tasked with establishing a regulatory framework to include licensing of producers and distributors, implementation of quality control standards, and a few other elements. The new bill also makes workplace discrimination based on the use of cannabis unlawful. So in addition to New York, New Jersey signed its legislation bill into law on February 22nd of 2021, and this legalized recreational cannabis use for adults. Virginia and New Mexico are among some other states that have passed legalization bills in 2021, and there's still others considering similar actions. These federal and state developments appear to be going in somewhat opposite directions. Let us talk about what impact this all has on the cannabis industry as a whole. But before we dive in, I am excited that we have two guests today. We welcome back my colleague, Delia Deschaine, from our last episode. As a refresher, Delia is a member of the firm at EBG and maintains a practice in cannabis law, advising a wide spectrum of clients not only on cannabis-specific laws and regulations, but also on the associated legal and compliance risks related to FDA, DEA, and the Controlled Substance Act. Welcome back, Delia.
Thanks, Megan. I'm happy to be here and look forward to our discussion today.
Great. And in addition, we welcome Nathaniel Glasser, who is also a member of the firm with EBG's Employment, Labor, and Workforce Management practice. Nathaniel counsels clients on the impact of state cannabis laws on employment policies and has written and spoken extensively on this topic. He is another leading member of the cannabis team here at EBG, and we are happy to have him join us for this discussion. Welcome, Nathaniel.
Thank you, Megan. I'm looking forward to today's discussion. I work with companies across industries, including in healthcare, to handle their employment and workforce issues. Cannabis and its impact on the workplace is one of those areas that I followed quite closely. And as you noted at the top of the podcast, there have been many developments in that area recently.
Great. And I know we have a good amount to cover today as far as those developments go. So let's go ahead and dive in. I think a good place to start is sort of on the federal level to address the impact that FDA's recent warning letters have on businesses marketing any products that are containing cannabis or cannabis derivatives like CBD, and what insight those warning letters might give industry on the direction FDA is taking in its development of a more cannabis-specific regulatory landscape. It seems to me that FDA is focused on CBD as an ingredient in those products, since the agency maintains that CBD as an approved drug ingredient cannot be marketed in foods or dietary supplements without agency approval. And these warning letters may be a way of FDA reiterating this position to show that even broad therapeutic claims for just pain relief make a CBD product illegally marketed. Delia, I'm curious to know your thoughts on that.
Yeah, thanks, Megan. So I wouldn't go so far as to say that FDA's warning letters are a signal that FDA is targeting consumer products that simply include CBD as an ingredient. However, the warning letters are a sign that FDA is being more aggressive in its enforcement actions against CBD products than it has been in the past. Up until the issuance of these letters, FDA focused its CBD enforcement actions on products that purported to treat serious debilitating conditions such as Alzheimer's disease, cancer, or even COVID-19. However, these more recent warning letters take FDA's enforcement actions a step farther by targeting companies that make claims about CBD being effective as a treatment for pain. This is not the same type of egregious claim that FDA has targeted in the past, and therefore definitely signifies a policy shift by FDA in its enforcement towards being more aggressive towards CBD consumer products more broadly. FDA's warning letters are also noteworthy because they signal FDA is taking or memorialize a definitive stance that FDA has taken on the inclusion of CBD as an inactive ingredient in OTC drug products. In its warning letters, FDA makes clear that a company cannot claim an ingredient is inactive at the same time that it markets that ingredient as having a therapeutic effect. FDA also takes the position that CBD is categorically unsuitable for use as an inactive ingredient in OTC drug products based on the known pharmacological effects and safety risks associated with CBD. What's interesting is that FDA's warning letters do not address the potential pharmacological and safety differences that may exist between FDA-approved oral ingestible CBD products and topical products that contain CBD. Regardless, I think FDA's warning letters are a clear shot across the bow to companies that are marketing CBD consumer products and who make therapeutic claims about those products. They are a sign that the development and marketing of consumer products that contain CBD deserves careful attention, especially as FDA's law and policy with respect to these products continues to develop.
Yeah, absolutely. That was really helpful. Thank you, Delia. I guess with FDA seemingly focused on continued enforcement actions against the sale and marketing of CBD products, it seems that states are continuing to expand access to cannabis products for adults, either recreationally or medically. We see states like California that now have effective licensing regimes for cannabis commercial businesses like laboratories, manufacturers, distributors, retailers. And now more states are starting to follow suit, like, mentioned previously, New York. Nathaniel, can you talk a little bit about how businesses and employers can navigate these developing state regulatory regimes? For instance, as recreational product use is legalized and the products become more widely available, how are employers having to adjust their policies for use of these types of products?
Well, for employers, the focus really has been on how the states regulate or intend to regulate THC, which is the principal psychoactive component of cannabis, and whether those laws provide any protections to their employees who may be using cannabis. We'll talk about California and New York specifically because I think that reference makes a good comparison. But this legalization effort really is no longer a phenomenon along the coasts. As of this week, 37 states and the District of Columbia have legalized medical marijuana, and 17 of those states, as well as DC, have legalized recreational or adult use cannabis, including my home state of Virginia, which became the first state in the South to do so. And certainly this sea change in policy across the states has left employers struggling to keep up, even though cannabis remains a Schedule I controlled substance under the Federal Controlled Substance Act, and it's still illegal under federal law. That the federal government's policy since the Obama administration has been to relax enforcement. So it's imperative for employers to keep up what the states are doing along legalization lines. And even when two states legalize cannabis, the differences in implementation and the employment protections can be stark. You can place legalization efforts into three buckets. One are those that decriminalize possession of cannabis. Another are those that permit the use of medical cannabis. And then the last group are those that fully legalize and allow for recreational use. But even within those buckets, states take different approaches to the interaction between cannabis and employment. Megan, you mentioned California and New York. Let's look at those two as examples. California became the first state to legalize medical cannabis in 1996. Certainly at the forefront of legalization efforts, but that statute did not provide any express employment protections for lawful users. In 2008, in fact, in a case called Ross versus Raging Wire Telecommunications, the California Supreme Court held that employers are not required to accommodate an employee's lawful medical use of cannabis. Even though California legalized recreational cannabis 5 years ago in 2016, that statute, again, didn't provide any express employment rights to users. If we fast forward to April of this year, there's a case called Espandola versus Wismatech Asian Foods in the Central District of California, and that court upheld the employer's right to enforce a uniform pre-employment drug testing policy, which resulted in the termination of employment or the refusal to hire the plaintiff in that case. But if you contrast that with New York, first of all, in 2014, New York legalized medical marijuana, and under its Compassionate Care Act, certified medical cannabis patients are deemed to have a disability under the state human rights law. What does that mean? Effectively, companies must accommodate certified patients' use of cannabis rather than refusing to hire or immediately terminating them for a positive cannabis test. In April, as you mentioned, and just before the Espandola case was decided in California, New York passed the Marijuana Regulation and Tax Act, which not only expands the Compassionate Care Act, but it legalized recreational cannabis in the state and does something unique in that it amends the state's lawful off-duty conduct statute to prohibit employers from taking adverse action against an employee for using cannabis off-duty and away from work. Basically, employers in the state can no longer pre-employment screen for cannabis and refuse to hire applicants who might test positive on that screening. And we see similar movement in other locations. Philadelphia passed a similar ban on pre-employment testing that's going to go into effect on January 1st of 2022. And New York City and Nevada also had prior pre-employment screening bans in place. But unlike this New York statute and unlike New Jersey, which followed suit, these statutes make exceptions for safety sensitive positions. I think what will be significant, particularly in the healthcare industry, is that under the New York state law, practices that routinely screen their providers for cannabis use may need to now switch policies because there is no exception for safety sensitive positions like a doctor or nurse or other healthcare provider. And besides narrowing the exceptions to these pre-employment screening bans, the New York state law also requires an employer to be able to show specific articulable symptoms of on-the-job impairment in order to take an adverse action to discipline or to fire somebody for using cannabis. Certainly, we're helping employers in New York review and reconsider their drug screening policies, especially as they relate to cannabis. We're also doing this for employers throughout the country because some employers want to take the same approach wherever they operate, even if it means following the most restrictive rules like we're seeing in New York and now New Jersey. Others want to take what they consider to be a more compassionate approach and not automatically refuse to hire or terminate someone based on a positive single test. And others are having difficulty recruiting talent into certain positions if they take that zero tolerance approach. So these state laws and the continued legalization of marijuana across the country are impacting employers in many different ways.
Yeah. And in addition, to employers having to kind of navigate all of these evolving state laws and all the nuances that come with each of them, right? I think it's also interesting to see how, just more broadly, not just in the employment context, states are looking at what FDA is doing and applying that to their own actions and even in the court system. So I know in our first cannabis podcast, we mentioned that several courts had issued stays on cases where plaintiffs were bringing claims against companies marketing CBD products, mostly about labeling and what they marketed their ingredients to include. And actually just recently, a California court looks like it's allowing a case to go forward, even though FDA still has not issued an updated regulatory official landscape around cannabis and CBD products. So that's going to be interesting to watch as well. I think, speaking of our last episode, it was titled Holding Pattern. I think that still remains more or less the case here when it comes to, as I mentioned, kind of waiting for FDA's official stance on the regulation of cannabis and cannabis-derived products, particularly CBD. However, it seems that the states are moving ahead at a pretty steady pace, in part at the urge of voters, to develop their own regulatory frameworks to allow various types of commercial cannabis activity. I guess, could each of you maybe give your thoughts on how you see this all shaking out over the course of the next year and kind of some hot ideas that the industry should be mindful of?
Sure. So I think we are witnessing a drive towards adult use only cannabis regulation and a slight migration away from state authorized medicinal use, which in my opinion eliminates some of the confusion around the intersection of federal and state law on this topic. At least it eliminates the need for consumers to understand the difference between FDA-approved therapies and cannabis that is prescribed by a physician pursuant to a state-authorized medical marijuana program. The latter, of course, not ever having been evaluated by FDA for safety and efficacy. We've seen a reluctance by the medical community to fully endorse state-authorized medical marijuana programs, and many physicians decline to participate in those programs, likely in part due to how these programs diverge from the traditional drug approval paradigm. I also think that we will, at some point, see change at the federal level in terms of how cannabis is regulated more broadly, both as a Schedule I controlled substance as well as a commercial commodity. In the meantime, while we're awaiting those tectonic shifts, I think it's important to make note of the gradual changes that are happening every day on cannabis law and policy that is important to cannabis business and other entities that operate in the marijuana space. So, as we discussed on our earlier podcast, the federal government has taken strides to make marijuana and marijuana derivatives more available to researchers in the US. And just last week, we saw some additional movement on that front. The US Drug Enforcement Administration announced that it is nearing the end of its review of certain marijuana grower applications, thereby allowing it to sooner register additional entities authorized to produce marijuana for research purposes. As part of this review process, DEA has provided a memorandum of agreement to a number of manufacturers that it believes satisfy the criteria for registration, which DEA has said is the next step of the approval process. I think this is important to pay attention to because once these cultivators are registered, that should significantly improve both the quality and quantity of marijuana and marijuana derivatives that are available for use in legitimate research in the US. In sum, I would encourage entities that operate in the marijuana space, whether they are businesses, academic institutions, researchers, or drug manufacturers, to pay close attention to not only the big ticket issues that are being discussed every day in cannabis law and policy, but also the less dramatic changes that might create real opportunities to pursue viable cannabis business or research opportunities in the US.
I would say that if the FDA, as you said in a prior podcast, is in a holding pattern, the states have taken over traffic control and are landing the planes, and others are taking off. To Delia's point that physicians are often reluctant to participate in state regulated programs, it's true that these programs do operate under a different paradigm. and they're often changing. And healthcare providers have to pay attention, for instance, to what cannabis use may be recommended in the state. I look at New York again, for instance, and under the recently passed MRTA, that statute expands the definition of serious medical conditions that will allow a practitioner to recommend a patient become a certified user. The method of use may vary from state to state. So although cannabis can be legally smoked in New York under a new Alabama law, which just passed this month, certified patients will not be able to smoke, vape, or ingest brownies or candies that contain cannabis. From an employer perspective, again, there are a number of legislative initiatives to legalize, whether it's medical or recreational cannabis in the various states. There are at least 3 states set to vote on legalization this year alone. Alabama just passed its law legalizing medical marijuana, although that statute expressly says it will not permit and does not intend to permit recreational use in the future. I think you discussed at the top of the podcast, Virginia and New Mexico are 2 additional states that have legalized recreational marijuana. And so it's really important for employers to be prepared for additional changes to the legal landscape. And they have to continuously monitor and reconsider their drug testing and drug screening policies and procedures in light of these changes to make sure that they are both legally compliant and they're going to be able to attract and retain the available talent in the marketplace. That's going to be extremely important as companies ramp back up as we come out of this pandemic and hopefully come back to the office. For companies looking to invest in the industry, I think another thing to think about and to pay attention to are the number of state provisions that are intended to promote social equity. States that have legalized cannabis recently often have social equity programs that allow, for instance, for equity licenses for people who may live in designated areas that have had a high rate of arrest and incarceration for cannabis-related activity. Places like New York, New Jersey, Virginia, California, Illinois, Massachusetts, and Michigan, just to name a few, have these provisions. From a labor perspective, a number of states, New York, New Jersey, and Virginia, have joined California this year in enacting recreational cannabis laws that limit the ability of employers to interfere with union campaigns to organize their cannabis workers. We also see that unions are making efforts to organize this industry. And so anyone interested in investing and owning a business within the cannabis industry must be aware of these efforts and be prepared as they apply to enter the industry to comply with these rules and regulations coming in.
That was all really, really great information, great discussion. Delia, Nathaniel, thank you so much for taking the time today to chat with me about these cannabis developments. Just as a recap for our listeners, we had a couple of kind of key points throughout the discussion today. I think some key takeaways are we're still waiting for an official regulatory landscape to be announced by the FDA, but just because they haven't issued a final regulation yet, that doesn't mean that the agency won't be taking enforcement actions like warning letters in the interim. Those can be viewed to kind of see how the agency is thinking about its position on marketing of various cannabis and cannabis derivative products. In addition, businesses operating in the cannabis space and employers and any players in the industry really need to pay close attention to the nuances of these state legalization laws as they are passed and become effective, because as we talked about today, there are different details in, for example, recreational versus medicinal use and various details about employment practices like discrimination considerations are in these statutes. And, it'll be important to see how they play out state by state. And then finally, I think Delia said this well, all players in the industry will need to pay close attention to the gradual changes happening every day in this space, because there are, of course, these big ticket items to follow, but there's something new every day. And all of that is going to contribute to the ever developing landscape of cannabis regulation. So that is all we have time for today, everybody. On behalf of EBG, thank you so much for tuning in. I'm Megan Robertson, and this has been Diagnosing Health Care.
Thank you for listening to Diagnosing Health Care. For show notes on today's episode, additional episodes, and more insights on trending issues in healthcare, please visit diagnosinghealthcare.com and be sure to subscribe on your preferred platform. The Employment Law This Week and Diagnosing Healthcare podcasts are presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of the legal services to be performed is greater than the quality of legal services performed by other lawyers.